I see we're live.
Okay, yeah, it's live now.
All right.
I see we're live.
Yep, you're live.
Good. I'd like to call to order the Municipal Officers Electoral Board meeting for today for Belcher versus Higgins 2020 DMOEB 05. Let the record reflect it is 2:05. Okay, please be advised that on December 11, 2020, the governor of the state of Illinois issued his latest statewide disaster proclamation related to continuing public health emergency posed by the COVID-19 pandemic, and has further issued executive orders implementing further enhanced mitigation measures and restrictions. As such, pursuant to Section 7E of the Illinois Opens Meeting Act and the Rules of Procedure, and as chair of this board, I have determined that holding a meeting entirely in person that is otherwise conducted in full compliance with the Illinois Open Meetings Act is neither practical nor prudent because of the ongoing pandemic. To the extent necessary, this meeting will be conducted with the option to participate via internet teleconference and without requiring the physical presence of a quorum. I further find that due to the disaster, the physical presence of more than 10 people at the regular meeting location in an accessible, hygienic, and legally compliant manner is not feasible. Alternative arrangements have been made to allow the public to hear all discussion, testimony, and roll call votes via Zoom teleconference. All votes shall be conducted by roll call, and verbatim record of this meeting shall be made and maintained in accordance with the Opens Meetings Act. All participants are hereby further notified that participating at this meeting, they acknowledge and are informed of this meeting's public recording. Thank you. The introduction of the Electoral Board. Will you take the roll, Madam Clerk?
Chair Rogers,
Here.
Clerk Dugan here, Trustee Henyar.
Present.
Okay, there's a quorum established. Is there an appearance by any attorneys?
Dennis Giannopoulos appearing on behalf of the candidate Charles Higgins.
James Vasselli appearing on behalf of the objector, Belcher.
Amber Samuels on behalf of the Electoral Board.
Okay, good. Is there any public comment? Derek? Hello, Derek?
So I have the YouTube up on one of my screens, and I do not see any public comment.
Okay. The recap of the status and the filings. Initial hearing held on December 15, 2020, and case management order was issued subsequent thereto. A hearing was held on objections motion to disqualify on December 21st, 2020. The motion failed. The candidate filed a motion to strike and dismiss on December 23rd, 2020. Proceeding on the objections, Belcher versus Charles Higgins, 2020 DMOEB-05. Candidate's motion to strike and dismiss objections, verified petitions. Preliminary motions or arguments by parties. Candidate to argue first.
The candidate, Charles Higgins, has filed, as indicated by the chairman, a written brief in support of the motion to strike and dismiss. The issue before the board was pretty plain and pretty simple. The objection can be found, the sole objection can be found in paragraph 7 of the objector's petition, wherein it is alleged that the candidate's nomination papers, and specifically the statement of candidacy and the petitions, are false and invalid because the candidate failed to fully and completely state his name on these documents. The issue complained of is the fact that the candidate, although correctly listing his name, Charles Higgins, omitted his middle initial. And the objector alleges that the requirement of a middle initial, or the failure to include the middle initial is fatal. However, there's nothing to support that assertion contained within the Illinois Election Code. There is, however, a provision directly on point in the Illinois Election Code, which is found at section 10-5.1, where the legislature provided as follows, and I quote, "In the designation of the name of the candidate on a certificate of nomination or nomination papers, the candidate's given name or names, initial or initials, a nickname by which the candidate is commonly known, or a combination thereof may be used in addition to the candidate's surname. The candidate provided his given name, that being Charles. The candidate provided his surname, that being Higgins. The candidate was not required to list a middle initial. The statute allows for the listing of a middle initial if a candidate so desires, but does not compel it. The Illinois Supreme Court has long recognized that a middle name or initial is not material in any legal proceeding, and that is a quote from the court, and that is found in People X is done, citation 247 Ill 410 93 Northeastern at 305, citing to Thompson v. Lee at 21 Ill 241. So the Illinois Supreme Court has long recognized that a middle name or initial is not material in a legal proceeding. The Illinois legislature in section 10-5-1 provides that providing a middle initial is discretionary and not mandatory. For the reasons stated in the brief, the candidate moves for the entry of an order granting his motion to strike and dismiss the objector's petition. Nothing further.
Ms. Samuelson?
Any argument from the objector?
We will stand on our objection, and we'll put on the record that we did not file a response to the motion to strike. Thank you.
At this time, does the board have any questions for either of the attorneys?
I have no questions.
None.
Okay. Any further board deliberations?
Okay, I'm just trying to make sure I understand. So, are you guys stating that we're not moving forward, correct? With the case that Dennis, your guy, is staying on the ballot? Is that the understanding that I have? Is that your argument, right?
Well, if you're referring to me, Trustee Henyard, my
Yes.
argument is that the objection filed isn't sufficient to keep my client's name from appearing on the ballot, and that the board should enter an order overruling the objection that has been filed.
Okay, so I understood. And James, Attorney James, I'm mixing everybody up. You're saying that you have no objection to him, correct?
What we're saying is we did not file a response brief, and all objections we would make or all statements we would make are already set forth in the objection that was filed.
Okay, thank you. I understand. All right, I just needed clarity, you guys. That was it. Appreciate it.
I would suggest that we vote on it.
Mayor Rogers, can I make my recommendation to the board as the attorney?
Sure.
Okay. Just as an overview, so this is, we talked a little bit in previous boards about questions of fact and questions of law. This is a question of law. The candidate is saying there's no legal basis. There's nothing in the election code that requires the candidate to include his middle initial. And so when there's, this is an issue where it would be appropriate to grant a motion to strike and dismiss. And in looking at the election code, there 10 ILCS 5-7-10.2. The statute has 3 distinct provisions. The first concerns the name the candidate may use on the nomination papers. The candidate may use his given name or names, initial or initials, a nickname by which the candidate is commonly known, or a combination thereof. But and must also use his surname. There's nothing in the election code requiring that a middle initial be used. So the fact that a middle initial was not included on the candidate's nomination papers is not a basis to remove him from the ballot. He was never required to use that middle initial in the first place. So my recommendation to the board would be to grant the motion to dismiss and strike.
That'll be a vote to overrule.
It would be it would be a motion to grant, or you would make a motion to grant the motion to dismiss and strike. If the motion to dismiss fails, then we would go on to argument on the underlying objection. But because this is a question of law, it's not a factual question. It is the type of case where this type of motion would be appropriate.
Okay,
I move to grant the motion to strike and dismiss.
second. So in rule, it's a motion to strike the
Objection.
objection and dismiss. Any discussion? No discussion, roll call.
Chair Rogers?
Aye.
Clerk Dugan? Aye. Trustee Henyard?
Aye.
Motion carries. 3 ayes. Okay. I guess we can recess to the other matter or adjourn to the other matter.
So since I'll put together a written decision for the electoral board to finalize and serve upon the parties electronically. If any party is not present, the final executed decision will be emailed to them with a copy sent via certified mail. So what we need to do is set this for a date where you review the decision and you sign it. And we can, does anybody have an objection to doing what we did in the mayoral boards, where we set the date certain after we have a hearing on the next case, so that way they're at the same date?
No objection.
No objection.
No objection here.
Okay, so let's, we'll do the motion to recess this board after we finish with the next case. So at this point, if the mayor wants to move on to the next one, to do the Towers case.
Let's move right on.
Yes.
Okay. I'd like to call to order the case docket Belcher versus Towers, 2020 DMO EB 07. Okay. Please be advised that on December 11, 2020, the governor of the state of Illinois issued his latest statewide disaster proclamation related to the continuing public health emergency posed by the COVID-19 pandemic, and has further issued executive orders implementing further enhanced mitigation measures and restrictions. As such, pursuant to Section 7E of the Illinois Opens Meeting Act, and the rules of procedure, and as chair of this board, I have determined that holding a meeting entirely in person that is otherwise conducted in full compliance with the Illinois Open Meetings Act is neither practical nor prudent because of ongoing disaster. Excuse me. To the extent necessary, this meeting will be conducted with the option to participate via internet teleconference and without requiring the physical presence of a quorum. I further find that due to the disaster, the physical presence of more than 10 people at the regular meeting location in an accessible, hygienic, and legally compliant manner is not feasible. Alternative arrangements have been made to allow the public to hear all discussion, testimony, and roll call votes via Zoom teleconference. All votes shall be conducted by roll call vote, and verbatim record of this meeting shall be made and maintained in accordance with the Opens Meeting Act. All participants are hereby further notified that participating at this meeting, they acknowledge and are informed of this meeting's public recording. Introduction of the Municipal Officers Electoral Board. As stated and explained at the prior hearing in this meeting, I am Riley Rogers, Chairperson of the Electoral Board. Also serving on the Electoral Board is the Village Clerk, Mary Kay Dugan, and the Senior Trustee, Tiffany Henyar. These members are provided by the Illinois Election Code, which mandates our service to hear and pass upon objections filed against candidates' nomination papers. Madam Clerk, will you take the roll?
Chair Rogers.
Here.
Clerk Dugan here. Trustee Henyard.
Present.
A quorum has been established. Are there any appearances by other parties or attorneys?
Dennis Giannopoulos appearing on behalf of the candidate Gail Towers.
James Vasselli on behalf of Objector Belcher.
Amber Samuelson on behalf of the Electoral Board.
Okay. Everybody's made their appearance, filed their appearance, I would imagine. Okay, is there any public comment? Attorney Samuelson?
No, there's no public comment.
No public comment. Recap of the case status and the filings are as such. Initial hearing was held on December 15, 2020, and case management order was issued subsequent thereto. A hearing was held on objectors' motions to disqualify on December 21st, 2020. The motion failed. The candidate filed a motion to strike and dismiss on December 23rd, 2020. Proceeding on the objections of Belcher versus Charles Higgins. Proceeding on the objections of Belcher versus Gail Towers, case number DMOEB-07. Okay, preliminary motions. Okay.
Does the board wish me to proceed?
Go ahead. I'm sorry, Dennis. Yes.
Okay, thank you.
Giannopoulos.
Thank you. Members of the board, before you today is the candidate's motion to strike and dismiss the objector's petition. This matter arises out of an objection that was filed attempting to raise a question as to the candidate's residency. We begin with an examination of section 10-8 of the election code, which requires that an objector's petition shall give an objector's name and residence address and shall state fully the nature of the objections to the certificate of nomination or nomination papers or petitions in question. The issue before this board raised in the motion to strike and dismiss is the objector's failure to state fully the nature of a cognizable objection meriting the removal of the candidate's name from the ballot. The objector's petition contains a single paragraph where the objector attempts to allege a residency violation, but comes exceedingly short in doing so. The gist of the objection, as best I can be ascertained, is that the property at which the candidate is alleged to reside, a property in South Holland, carries with it a homeowner's exemption, and that somehow that makes it fatal to the candidate's residency claim in her statement of candidacy. I quote from paragraph 6 of the objector's petition, where this allegation is found, where it's provided that as of the date of the execution of the statement of candidacy, the candidate has not changed the homeowner's exemption status of the property at 15241 Naughton Drive, South Holland. And by operation of law, she currently occupies and resides at the property at 15241 Naughton, South Holland, Illinois. I submit to the board that the issue of residency is not determined by operation of law, and it's certainly not determined by whether or not a specific piece of real property in an adjacent community enjoys a homestead exemption. The issue of whether or not a homestead exemption is claimed on a particular parcel of property may be relevant if it's inappropriate in the eyes of the assessor after an investigation, but the eyes of this electoral board is limited to determining whether or not the objections state fully the nature of the objection. And I submit to you that the allegations contained in paragraph 6 fall woefully short of asserting a viable claim for a residency violation. Residency has recently been addressed by the Illinois Supreme Court in the case of Maxim versus the Board of Election Commissioners. That's found at 242 Ill 2nd 303, 950 Northeast 2nd 1051. And again, for members of the board that may remember, this case involved an objection to the purported residency of Rahm Emanuel when he sought to run for mayor of the city of Chicago. The Maxim case is instructive in that it sets forth the two required elements for making residency determinations, namely that a candidate or an individual maintain a physical presence and an intent to remain in that place as a permanent residence. No information is provided in the objector's petition addressing these particular elements set forth in Maxim, and accordingly, the objector's petition falls exceedingly short of the pleading requirements of a valid objector's petition. I did provide the board as an attachment with the Maxim underlying objector's petition to give an example of where specific factual allegations were deemed sufficient to allege a purported residency violation. It provided information regarding the candidate's residence, the alternative residence, actions taken in the summer of 2009, the move to Washington, D.C., the D.C. residence on Woodley Road in Washington, D.C., the moving of belongings, as well as his wife's and children's belongings from the Hermitage residence, and that he allegedly hadn't returned to the residence since vacating. There's a plethora of additional information provided, and this should give the electoral board a roadmap to follow of what it is to plead to state fully the nature of a residency objection. I submit to the board that the bare bone allegations that are contained in paragraph 6 fall woefully short of the pleading requirement. If this were in the context of a civil case involving a civil lawsuit, this wouldn't be fatal to the objector's claim. What it would certainly result in would be an order granting the motion to strike and dismiss, and then giving the objector an adequate period of time to take another shot at it, to try to frame out the necessary allegations. And in the civil courts, oftentimes a motion to strike and dismiss can be granted 1, 2, 3, 4 times, and the courts will give virtually every reasonable opportunity for a claimant to set forth a cause of action. Unfortunately, that provision or that manner of dealing with motions to strike and dismiss that have been granted doesn't apply to the electoral board proceedings, because the objection proceedings specifically prevent and preclude any amendment of an objector's petition once it's filed. So again, if this were a civil case, this error wouldn't be fatal, but could be cured perhaps on repleading, setting forth sufficient facts. But in the context of the forum where we're at, where there's going to be an election held this February, come hell or high water, there isn't the opportunity to allow an objector to go back to the well multiple times to get it right. I submit to the board that the objector failed to get it right, and for that reason, the motion to strike and dismiss should be granted. Thank you.
Any response to that, Attorney Vasselli?
Thank you, Mr. Chair. Good afternoon. Objector respectfully disagrees with counsel. As you know, the motion we are looking at before here is a motion to dismiss. At this hearing, a motion to dismiss, all well-pled facts in the objection petition are admitted as true. The standard for this hearing is that with those well-pled facts taken as true, Objector Belcher is entitled to relief, the removal of candidate Towers from the ballot. At this level and under this standard, the answer is simple, that the motion to dismiss should be denied. Taking the pleadings as true, candidate Towers abandoned her residence in Dolton in favor of a residence in South Holland. forfeiting her ability to run for office in the village of Dolton, pursuant to the tenets of the Illinois Election Code. Today's hearing is neither a trial nor a hearing on the merits. The Code of Civil Procedure is irrelevant. It's very artfully stated by counsel, but the fact is simple. All the facts are taken as true. The standard is low in this matter to proceed. Should the motion go forward, there will be time for a hearing on the merits, which counsel is trying to do at this motion level, or a hearing on the merits, which counsel is trying to do here today, but that is not the standard. It is a limited hearing today. And again, while counsel's arguments are articulate, they are irrelevant. This is a very simple matter. The facts are admitted as true. The standard is, if those facts are true as taken, should the motion be denied, and should the relief be granted, and thus the motion be denied. And it's just that simple. Thank you, Chair.
Any rebuttal, Attorney Giannopoulos?
Just briefly, and then that is that the only factual allegations that are pled are a factual allegation as to the existence of a purported homestead exemption. I submit to the board that this isn't a situation where the well-pled facts must be construed in favor of the non-moving party, because quite candidly, there aren't any well-pled facts on the issue of the residency allegation. And the one that is alleged regarding a homestead exemption has no bearing. The homestead exemption can be claimed by individuals renting the property, by individuals with an obligation to pay taxes. It doesn't shed light on the issue, and it doesn't set forth specific facts on the issue of the ultimate fact, and that is the residency of the candidate. Thank you.
When you cross on that, Attorney Vasselli?
Nothing other than the fact it is a well-pled fact. It is an indicia of ownership. It's just that simple. All we need is well-pled facts to go forward. It is a low standard to survive a motion to dismiss, and we've sustained that. Thank you, Chair.
Okay, Attorney Giannopoulos, you rest?
I rest.
Okay. Any recommendation from the board, Attorney?
This is a factual issue. Previously, we had an issue of law. This is an issue of fact. And issues of fact, you typically have to have some sort of evidentiary hearing to establish the facts. So my recommendation to the board is that in this case, it would be appropriate to deny the motion to strike and dismiss, and to set this case for an evidentiary hearing as to the candidate's residency.
Okay. Any questions from the board members? Discussion.
Hi. Well, I totally agree with Attorney Amber. I'm sorry. I agree. I think we should let it be heard as it relates to the facts, if she stayed there or not. I think the benefit of getting a homeowner's exemption is you have to stay at the property. If you get one, then you're defrauding either the county, or you're defrauding the voters by saying you stay here in the village of Dolton. So I would love to hear the facts as it relates to the evidence. And I think we should move this forward to the next hearing so we can hear what the subpoenas brought in. Because I was a little confused on them going back and forth today when I thought they both, meaning both attorneys, agreed to get subpoenas and go before us with evidence. So I still agree with that.
I would recommend that the board take a vote on the dismissal and striking this objection. And if the attorney for the objectors wants to move forward with the evidentiary hearing, so be it.
I make a motion to deny the motion to strike and dismiss.
I second it. Any discussion here? No discussion, roll call.
Chair Rogers?
Aye.
Clerk Dugan? Aye. Trustee Henyard?
Aye.
Motion carries, 3 ayes. Attorney Samuelson,
Yes.
you want to move forward with this?
So the next step would be to, since the motion to strike and dismiss was denied, the next step would be to set this for hearing on the objector's case in chief. So we have to pick a date to have an evidentiary hearing. So that's where all the subpoenas came in. They were gathering their evidence. So the question I guess I have for the parties is when what would be good for you guys to come back?
Hold
When's
on.
the next? Sorry, Chair.
Hold on a minute. The motion was to strike and dismiss.
Thought the motion was to deny the motion to strike and dismiss. Clerk Dugan?
Yes. Motion to deny the motion to strike and dismiss. So we would then, I understand, move on to an evidentiary hearing.
I was a little confused there. I want to strike and dismiss this motion, this objection.
We already voted. We all agreed that we move on to the evidence, Mayor.
Is that what the motion was, Madam Clerk?
Yes, the motion was to deny the motion to strike and dismiss.
And at this time, I cannot change my vote.
Well, I don't know if it's for me to speak to that, Mayor, but you would still have 2 votes in favor of the motion to deny.
And it was the recommendation of the attorney, Attorney Amber. And we
Yeah.
all agreed as board members. So I don't understand what's the issue now.
I believe the issue is a non-issue at this point. Correct
Okay.
me if I'm wrong.
Okay, let's move forward.
Yeah. Okay, so to the parties, I guess and I don't know also when the board is available. I know that we have another evidentiary hearing set for December 4th. So I would not recommend the 4th. But sometime next
Not
week.
December, not December.
January.
It's January 4th, sorry.
Yeah, no, yeah.
So
Happy New-
I would not recommend, I would recommend sometime next week, obviously not January 4th. If that's okay with the board, with the parties to have set the hearing for next week. I guess the question is the board available on either the 5th or the 6th?
I am.
The 5th is good for me.
So am I. Either date is good.
Okay. Can the parties be ready by January 5th?
5th works.
We'll make it work in the afternoon.
In the afternoon? Do we want to stick with 2 o'clock or do we want to bump it up to 1?
I would say 1.
Okay.
Okay with the attorneys.
I don't have a preference.
If the clerk wants 1, it's 1. We're good.
Okay. And then on the Higgins case, since we're coming back on the 5th at 1, do we want to do Higgins shortly before that at 12:45?
That's fine.
That's
Yeah, that works.
no objection.
All right, so I guess I would ask for a motion to continue the Towers case for hearing on January 5th, 2021 at 1 p.m.
So moved.
So moved. Oh, okay. Second.
Roll call, Mayor.
Yes.
Chair Rogers.
Aye.
Clerk Dugan, aye. Trustee Henyard.
Aye.
Then we're going to do 2 separate motions to recess. So a motion to recess Belter versus Higgins 2020 DMOEB 05 until January 5th, 2021 at 12:45.
Like a motion to recess case number 2020 DMOEB-05 to January 5th at 12:45.
Second.
Been motion and second to recess the case until January 5th, 2021 at 12:45. Roll call.
Chair Rogers?
Aye.
Clerk Dugan, aye. Trustee Henyard?
Aye.
Motion carries.
And then we would need a motion to recess Belcher versus Towers 2020 DMOEB 07 until January 25th, or January 5th, 2021 at 1 p.m.
Make a motion to recess the Towers case 2020 DMOEB-007 to 12:45 on January 5th, 2021.
Second.
Yes, it's been set, motion and second and roll call.
Chair Rogers?
Aye.
Clerk Dugan, aye. Trustee Henyard?
Aye.
Motion carries, 3 ayes. Like a motion to adjourn this meeting.
Do we need that?
We don't need to adjourn since
Okay.
we've motion to recess.
Yes, okay,
We don't adjourn until we're all done.
okay.
The decisions are signed.
Thank you.
All right,
Happy
thank
New
you.
Year.
Good
Happy
afternoon.
New Year.
Happy New Year.